Officer Carter of the Biloxi Police Department. The reason I'm stopping you is you cannot yell out the window when I'm on a traffic stop. I need your driver's license.
That's First Amendment right, infringement.
It's called interfering.
That's First Amendment right, infringement, and I can sue you for that.
Driver's license insurance.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Man, have I got a doozy for y'all today. Our video comes to us from the YouTube channel West Texas Audits. That's a channel I had never heard of, but I just happened to be scrolling through the YouTube suggestions last night and decided to give it a watch. It depicts a person who I assume is the channel owner for West Texas Audits as a passenger in a car when the driver is pulled over in Biloxi, Mississippi because his passenger, the person I assume is the owner for West Texas Audits, yells out to a police officer while he's conducting a traffic stop to let that boy go. Now, I haven't made any substantial edits to the video with the exception of dropping out some of the audio so I don't get a copyright strike for the music that was playing in the background during some of the dead space, but you should head over to the West Texas Audit channel to show the owner's support for documenting and sharing his experience with us. With that, let's watch some of the video and then we'll come back and talk about the law.
Violate my First Amendment right, baby. I didn't cuss at you or anything. We ended up here. I said just leave that boy alone, that's all I said. I didn't cuss or nothing. We didn't do nothing wrong.
Officer Carter of the Biloxi Police Department. The reason I'm stopping you is you cannot yell out the window when I'm on a traffic stop. I need your driver's license.
That's First Amendment right, infringement.
It's called interfering.
That's First Amendment right, infringement, and I can sue you for that.
Driver's license insurance.
Okay, so right from the beginning, we see that young officer Jay Carter of the Biloxi, Mississippi Police Department approaches the passenger side of the vehicle. Now, they are in pretty heavy traffic. You can see that they are pulled over on a part of the road where the vehicles are coming by pretty rapidly with the driver's side. So it's not altogether strange that he would approach from the passenger side, but it is kind of strange that he doesn't actually address the driver at all. He first addresses the passenger, and he says to the passenger that the reason for the stop is that he has an issue with the passenger yelling out the window as he's on a traffic stop. Now, the passenger, of course, says that's a First Amendment protected activity and that he can sue Officer Carter for this stop, and Officer Carter then claims that it is the crime of interfering with an investigation. Now, guys, I have tried diligently to figure out what exact Mississippi charge Officer Carter is referring to here, and I have not been able to find an exact charge that fits this situation. That in itself is pretty telling. Now, you might ask, James, why would you try and find an excuse for this guy or find a law that actually fits? What matters is that the officer doesn't know the law, right? Well, unfortunately, no, that is not right, and here's why. What a lot of people don't seem to understand or get incorrect when it comes to these interactions is that the court gives officers a lot of leeway in judging whether or not their conduct was appropriate. So much so that it actually doesn't really even matter whether the officer in question knows the law. Now, I know a lot of your blood pressure just went up, but before you stroke out, just stick with me for a second and let me explain. The court applies a standard of objective reasonableness to these type of encounters. What actually matters is what information the officer had at the time. And then it matters what a reasonable officer in the same situation would do with that information. So in other words, they'll take everything that Carter knew and then they'll run it through the lens of this reasonable officer. The reasonable officer is a derivative of the reasonable person standard that is used in courts. This is not a topic that I've hammered home on this channel very much, but the courts use a reasonable person standard for almost everything. And the person they describe when they talk about the reasonable person doesn't actually exist. In my opinion, the reasonable person standard should actually be called the perfect person, Because you see, the reasonable person always does the right thing. They don't make mistakes. Their tint on their windows is the exact amount allowable by law. They never speed. They never run stop signs. They slow down in the rain. They understand everything they're responsible for knowing under the law. They never break the law. They're always right. They always do the reasonable and correct and prudent thing. So when the court applies an objective reasonableness standard to police officers, they basically create a police officer with similar training and experience, and then they ask what that officer would do in the same situation if that reasonable officer had the same information that Carter had at the moment of seizure. Now, a reasonable police officer would know Mississippi law if he's going to be policing in Biloxi, Mississippi. And so if there is a law that applies to this situation, the court will fit that law to the facts in the application of the objective reasonableness standard. And that's why it's important when you're judging the conduct of the police officers in these interactions that you go ahead and try to figure out what law they're actually referring to, because that's what's going to happen in court. It gives you a better way to sort of set appropriate expectations for the final outcome. So that's why I tried figuring out what Carter actually meant when he accused the passenger of interference. So he cites interference with an investigation, but Mississippi doesn't have a specific interference code that I could find. It has a hindering statute, which refers to hindering the prosecution of a person by providing criminal assistance, and that has a very specific definition under the law. So let's look at it here and we'll figure out what Mississippi law says about criminal assistance. So for the purposes of this article, a person renders criminal assistance to another if he knowingly harbors or conceals, warns the other person of impending discovery, provides or aids with the money, transportation. It's kind of like an accessory charge. Prevents or obstructs by means of force, deception, or intimidation. That's not applicable. Suppresses by an act of concealment. That's not applicable. Threatens, harasses, or intimidates a witness or a person reasonably expected to be a witness in a criminal prosecution. That doesn't really apply. Provides false testimony. That doesn't apply. I would be the only thing that loosely applies, and it's attempts to prevent law enforcement from discovering facts relating to another's criminal activity. But again, yelling out the window, let that boy go, is in no way related to this code at all. And so I started looking at like disorderly conduct and obstructing charges. So we'll go through a couple of those too, but they don't apply either, just to give you a preview. Let's see, crimes against public peace and safety, disturbance of the public peace, person disturbs public peace by violent or loud or insulting or profane, indecent or offensive or boisterous conduct or language, or by intimidation or seeking to intimidate another person. Again, that doesn't really apply. That's like a breach of the peace type charge. I'm not going to put you guys through the whole code, but basically I couldn't find anything. I might have missed it. I mean, I obviously could miss it, but I didn't find anything in Mississippi law. I think this is clearly just a retaliatory stop where the guy wanted to try to find something to fit. I'm of the opinion that there wasn't an actual law broken here, and there was no actual good faith basis for thinking that. He just wanted the guy to believe that he broke the law so he could try to intimidate him. Now, the fact that we have no idea what law applies to this conduct matters for a couple different reasons. Number one, if there's no lawful basis for the detention, then we have a clear Fourth Amendment violation and a clear First Amendment retaliation case. And number two, because of what the officer says next. So let's watch.
I need your driver's license, and I need your driver's
First
license.
Amendment right
Step out of the
infringement.
vehicle.
Hey, no, don't do that, man. That's not...
No, get out of the vehicle.
No, I can sue you for that. Hey, call this out for me.
Hey, man, get out.
Here.
I'm ordering you out of the vehicle. Get out of the vehicle.
Man,
For what? I didn't do
Because
nothing wrong.
It's called Pennsylvania versus Mims. I'm ordering you out of the vehicle. You could not drive past my traffic stop and yell stuff out the window.
All I said
That
was
turns my
leave that
attention-
boy alone.
That turns
I
my
didn't
attention
cuss
to
at you,
It doesn't matter. That turns my attention
and
to
I
you,
didn't say
and he could
anything
have hurt
vulgar
me
to you.
while I was dealing with him.
I get it, but call Sky, bro.
Okay, get out of the car. We're not calling anybody right now. Get out of the car.
Oh, my lawyer is on the phone.
That's fine. He can be on the phone all he wants. Get
Here's
out.
my ID.
Okay, this is called Pennsylvania versus Mims, bro. I'm going to ask you one more time to get out of the car, or you're going to go to jail
For what?
for disobeying a lawful command. You drive license. Do you have any weapons on you?
Hey, sir.
Hey, man.
Yeah.
So, Reason for the stop?
No, I'm being cooperative.
Okay,
man.
so he yelled at the window.
I
Okay,
get
that's
it.
not
No.
only is that illegal, but your tent on the vehicle is also illegal. Okay.
Okay, but I get it. This is not my vehicle. I'm deep.
Yeah, he said it was his.
Yeah,
so tents on his vehicle is illegal.
Yeah.
So
do what you got. I respect it. I respect it. 100%. Yeah. Do what you got to do, man.
Okay, so now we have the double whammy. Young Officer Carter here decides he wants to cop-splain his justification for getting the passenger out of the car, and he repeatedly says it's due to Pennsylvania versus Mims, which is tragic because apparently nobody properly cop-splained to him what Pennsylvania versus Mims actually means. Now this, of course, makes me throw up in my mouth for a few reasons. First and foremost, because Pennsylvania versus Mims does not apply to cases where there isn't a lawful traffic stop based on a traffic infraction. This, if it is lawful at all, which we'll explore more shortly, is a Terry stop. The driver didn't do anything. He can be detained very, very briefly as a conduit to detaining the passenger, but that's it. Number two, Pennsylvania versus Mims has nothing to do with passengers. That is actually Maryland versus Wilson. In Maryland versus Wilson, the court extended the holding in Mims to passengers. They said basically if a person is lawfully stopped, again, lawfully stopped, and the court thinks it's legal and not a further violation of the Fourth Amendment to get a driver out, then the same rule applies to passengers for the sake of officer safety. And then the third reason that it makes me want to vomit is it's just evidence that instead of cops being trained properly on Mims and it being about officer safety, instead cops are told that Mims is the pathway to all the desires of their little tyrannical hearts, and that just isn't the case, and it drives me nuts that that's what they are trained to think. But you also might have noticed that Carter finally asks the driver for the information and tells him the reason for the stop has now become twofold. Number one, his buddy's not allowed to yell out the car, and number two, the tent is also illegal. The problem is that he didn't have any of the information on the window tent until after he had already stopped the car, and it almost has the feel that somebody somewhere said, hey bro, you actually need a lawful basis to stop the car, so you better say something about the tent because you can't just stop the car for somebody yelling out the window. And so the constitutionality of the stop still hinges on whether Officer Carter had a valid investigatory detention under Terry versus Ohio. So as a recap, under Terry v. Ohio, you need reasonable articulable suspicion that criminal activity is afoot in order to conduct an investigatory detention. That's a Terry stop. And then if you want to conduct a Terry frisk, you need information that the person is armed and presently dangerous. Now, again, we don't have a Terry frisk here. We've got no information. My guess is he probably was patted down. I can almost guarantee it, because if this cop doesn't understand what he's doing on the first few cases, he surely doesn't understand that Terry doesn't allow him to pat him down without armed and dangerous, but we don't know because we don't have that information. Reasonable articulable suspicion has to be based on specific facts known to the officer at the time of the seizure and can't just be like a non-particularized hunch that a law is being broken. I don't even think you have a hunch here. I think you have a young cop who got his ego twisted up because someone yelled at him on a traffic stop, and he stopped the person in order to intimidate them and threaten them to make sure they never do it again. That leads me directly into the First Amendment retaliation claim, and so it's been fairly well established in the Fifth Circuit that in order to prevail on a First Amendment retaliation claim, a plaintiff has to show three elements. All these elements are laid out in a Fifth Circuit case from 2023 called Perkins v. Hart. So the first element is that the plaintiff was engaged in a constitutionally protected activity. Well, I think at this point it's pretty well established that yelling at the police while they're working, flipping them off, or even cursing at the police is constitutionally protected speech. So in my opinion, the first element is pretty well met. The second element is that the officer's actions caused the plaintiff to suffer an injury that would chill a person of ordinary firmness from continuing to engage in that activity. Well, it's pretty clear that the police pulled him over, yanked him out of the car, violated his Fourth Amendment right in order to try to teach him a lesson about yelling at the police. And the whole design of that is to make sure that he doesn't do it again, which is the very definition of chilling someone's speech. To chill a person's speech is generally thought of as sort of stifling their exercise of that right. And then the third element is that the police officer's adverse actions were substantially motivated by the person exercising the constitutionally protected conduct, which it's clear from Carter's own words that he stopped the vehicle because he had an issue with being yelled at on a traffic stop, and he was going to try to make a law fit and attach it to whatever facts he needed to in order to retaliate. So all of these elements are met in my opinion. And again, back to the Perkins v. Hart case, which I'll link in the description. That case was about stripping qualified immunity from officers who shoved, threatened, and pointed a taser at a teenager because he was filming his aunt's arrest. So it's not exactly on point. He was standing on private property and he was filming the arrest. But because the alleged violation here is more of a disorderly speech kind of accusation than obstructing by being too close or physically interfering, it's a little bit different. But so long as you have a constitutionally protected activity that you're exercising, it pretty much plays the same. And thanks to our friend over at the BILOXI channel, who, if you don't know by now, is the original plaintiff in the Turner v. Driver case from 2017, filming the police has been established in the Fifth Circuit as a constitutionally protected activity, and it is being used as the basis for yanking qualified immunity from police officers who do this kind of stuff ever since that case was published. Because from then on, it became a clearly established right, which is one of the elements that you need in order to strip qualified immunity. In closing, it's absolutely clear from this video and many others that Pennsylvania versus Mims is being offered either in training academies or in the field training programs of rookie police officers as being a blanket justification anytime a police officer wants to get anyone out of the car. It is painfully obvious here that in citing Mims on this stop, Officer Carter has absolutely no clue what Mims actually stands for, how it traces its roots in DNA back to Terry versus Ohio, and the fact that it had a younger brother born a few years later called Marilyn V. Wilson that extended the rule in Mims to passengers. And that all of that is sort of encompassed by the rule about officer safety. An exit order under Mims or Wilson must be born of a lawful traffic stop, and it also has to be anchored to officer safety. Otherwise, it's not lawful. When a police officer stops a vehicle for a crime not related to a traffic infraction, it's governed by Terry versus Ohio, not by Mims. And they must have reasonable articulable suspicion based on particularized facts that criminal activity is afoot. This was very clearly a contempt of cop stop with no legal basis, and in my opinion, ripe for a slam dunk 1983 lawsuit for First Amendment retaliation and Fourth Amendment violations on not just the passenger, but the driver also. The passenger for all the reasons I've already mentioned, and the driver because he ends up getting detained the whole time along with his buddy and ends up facing scrutiny over a tent violation that wasn't discovered until the unlawful traffic stop happened. He didn't commit a traffic violation and they had no reason to detain him any longer than to get access to his buddy and give him an opportunity to go on. Now, unfortunately, this video ended right about the time that Officer Carter is telling the driver what the reasons for the stop are. So unfortunately, we don't actually know whether these guys were cited or arrested or just released after the attempted intimidation by Officer Carter. So if West Texas Audits ever watches this video, please reach out to me via email, which is listed on my community tab of my YouTube channel page, and let me know what happened so I can do an update. Anyway, that's all for this one, guys. Thanks for watching. Please remember to like and subscribe and leave a comment on the video. I invite you to check out other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.